Welcome in, everybody. This is Legal Aid Society of Mid New York's Town Hall series. We're doing one currently on the it's prudent to do because of the housing crisis that's been happening across the country and across New York State. And with us today is Emily, who's a LASMNY intern, and Clara O'Brien, who's a staff attorney who's gotten hired specifically to do some of help with some of the eviction cases happening in the central New York region. Let's just go around and just introduce yourself, say a little bit about your background and where you're at, and we'll take it from there. So go ahead, Emily.
Hi, my name is Emily. I'm a senior at the University of Rochester, and I am studying political science.
Cool. And Clara, go ahead, talk a little bit about your background and what area of law you're practicing currently.
Sure. Thank you, Alex. Thanks, Emily. So I'm a fairly recent hire. I moved up to Utica from Brooklyn, New York in early February, and I was hired, as Alex said, specifically to do eviction defense. So the courts are swamped right now. The local city, town, and village courts are swamped with eviction cases, partly because there was a longstanding eviction moratorium. So there's a bottleneck of cases. And so there's a lot of work to do. And we are trying to hire, really as many attorneys as we can to do this work. I do a fair number of cases in the Utica City Court, which is right, next to our office. But we also travel around to town and village courts in Madison County, Onondaga County, Herkimer County, so we see, sort of lots of different communities.
And I'd like to get into a little bit of that, like some of the Utica City versus some of the rural towns and stuff and what you're seeing. But, first question is really just, we had this eviction moratorium and evictions stopped across the state, and now they've opened back up over the past few months. So how are evictions being handled right now in the courts? I know it's probably kind of case to case on that, but what are you seeing in the courts and how the evictions, how it's been lifted and handled in the court system?
Courts have different ways of handling, very busy calendars. The Utica City Court, for example, has three judges that are there to sort of share the cases. A town like German Flats in Herkimer County, has two excellent judges, and I think their courts open once a week for these matters, and there will be a line of people, out the door. Some people jokingly call it eviction night. There's New York has what's called a summary proceeding for evictions, which is the idea is that it's a sort of short form. It's a balance between, we want to give, as a society, we want to give landlords a relatively efficient way to recover their property when a tenant is in breach of the lease. Something short of the full trial discovery that you would otherwise have. But at the same time, protect tenants' due process and other rights. So it's a creature of statute, a summary proceeding, and it's a relatively straightforward procedural requirements. And so city court judges are generally attorneys, but town and village courts are not always attorneys, and but they can that does not mean they're not competent to do summary eviction proceedings. As I said, the statute is pretty clear. It's also, the court provides various services, including a law library and forms online, so that small landlords can bring these cases pro se, meaning without an attorney. Obviously, having to hire an attorney raises the cost of evictions, raises the cost of running your business. And there's also, pro se materials for tenants defending against eviction. But I think there is a big push in New York State to fund programs like ours for low-income people to have attorneys in eviction cases, and it makes a huge difference. being represented by counsel makes a huge difference in outcomes. Yeah.
I have a follow-up question. So just as a person that's transplant as well to this region, so there's some town and village courts have judges that are not necessarily have the prerequisite of a JD. Is that correct?
Right. They're not required.
Okay.
But, they're often
like an election process, right? I'm guessing.
Yeah, they're elected and they're funded. I think a town and village court is funded with municipal funds.
Right.
They're still part of the state court system, but that isn't to say, they're incredibly competent people.
Sure.
Like a lot of things in life, you become good at doing something over and over for years.
Yeah.
You develop, not just the substantive knowledge of the law, but a real deep knowledge of your community. But yeah, that is one difference. And so I think the Office of Court Administration, for example, does a lot of work to, give sort of clear guidance for judges in bigger and smaller courts to understand how, for example, what does the ERAP stay mean? What are the exceptions? Things like that. And they also have I think it's called the Town and Village or the Justice Court Resource Center. Mm-hmm. So that local justices can call and get answers on more specific legal questions if they want.
Awesome. All right, next question, Emily, go ahead.
Yeah, so if you could just describe in lay terms what ERAP is and why it's so important.
Sure. So ERAP is what we call it. It's the long form. The name of the program is the COVID-19 Emergency Rental Assistance Program of 2021. And it is what it sounds like. It was the idea was to help tenants who fell behind on rent because, for example, they lost hours in their job because the businesses were closed during the pandemic or it wasn't safe to go to work. I've worked with a lot of nurses, for example, who themselves became sick and couldn't work. So there are a lot of New Yorkers in that position of very much wanting to work and wanting to earn and wanting to pay rent, but really just not being able to because of something outside their control. So the way ERAP works is if you qualify, and we can talk about eligibility later, but it's many people do qualify. It's not a strict standard, I would say. If you do qualify, ERAP will cover up to 12 months of rent arrears, which is 12 months past due rent, and 3 months perspective. So essentially, one way I look at it was a way to carry people through really extraordinarily difficult sort of economic time. And give your household a reasonable chance to get back on their feet, earning again so that they can cover their rent.
Okay. Now, is ERAP available to landlords as well to apply for funding?
There were landlord, yes, there was a separate program that landlords could apply to, but the ERAP, the tenant piece is what is still open, what is still, they're still accepting applications. And so that 15 months I described, 12 months arrears, 3 months perspective, that's for any rent from March 2020 on. And so that is focused for tenants. Now, another way, I look at it a lot, sometimes things get ugly in eviction court and, you'll hear a landlord grousing about, handouts to tenants. Another way I look at it, right or wrong, is there's also a form of income replacement. A lot of industries didn't have that kind of support during the pandemic, and small landlords, it is a form of income replacement, right? So I would say it provides its housing stability. It also provided some income support for landlords.
My next question is actually just dealing with what you just mentioned. How do you apply for ERAP? What are the guidelines? What are the kind of qualifications for that program, generally speaking?
The main qualification is that you either experienced income loss or expense increases tied to the COVID pandemic. So there has to be a nexus between why you fell behind in rent and the pandemic itself, and that looks really different for different families. For example, one person may be was able to continue working. They were doing Instacart or other work, all of those, workers that I was so incredibly dependent on when it wasn't safe to go out. So, that person may have been able to keep their own income coming, but their mother passed away from COVID, and they, had to cover funeral costs. And, when you live close to the margin, it doesn't take a lot to set you back. Yeah. Those kind of financial shocks, can easily sort of throw someone off. So, it's either a lower income or increased costs. And let me just quickly, I'll just read right from the eligibility. Reduction in household income, incurred significant costs. Household income at or below 80% of area median income. So that's a lot of renters.
Yeah.
I would say, Alex, that I believe like our, if you qualify, at least for LASMNY, for someone to qualify for free legal services, we are federally funded, and so there are strict income guidelines. So anyone who's eligible for our services, as long as there's a nexus to COVID and their financial situation, is going to qualify, is going to pass that 80% area median income threshold. And the other thing sometimes you'll see as an aside, you'll sometimes hear like a landlord or landlord counsel saying in court, oh, subsidized tenants aren't eligible for ERAP. And that's not true. What is true is that tenants, for example, who a portion of their rent is paid by a Section 8 housing voucher, and they contribute a different percentage, those tenants are eligible for ERAP, and many of our clients do have applied and have applications pending, but the statute is very clear that their applications will only be paid out with money that's left over once all non-subsidized tenant claims have been paid. And, the funding for ERAP program is always a sort of unknown. So it was initially funded by the federal government. There was I think of $800 million, a big chunk went in from the state budget most recently. And, the statute has a sunset of September 2025, and it is possible that there will sort of be money cycling through, like even if there aren't big infusions of money going forward, there are landlords who refuse to accept ERAP money, for example. And then, what they would be paid out gets put back into the pool and is available for other applicants. So it's never, it hasn't been truly unfunded.
Right. Okay. Excellent. Yeah, it sounds like there's a ton of options available for renters. And we'll kind of talk about a little bit of some other stuff too, as far as options and the dynamic of the landlord tenant. But I wanted to throw the next question to Emily.
Yeah. So for tenants whose landlords are threatening to forcibly remove them, is it possible, or are there stop holds in place that's to protect tenants?
Well, no. So it's not. So in New York, only a sheriff, marshal, or constable can evict someone. And they can only do that once they have an order from the court to do so. And that order is a warrant of eviction. So, very high level, an eviction proceeding, generally are either based on non-payment of rent or something called holdover, which simply means that the landlord has terminated the lease and the tenant continues to live there. That's holding over. So, in either of those two bases, you start with some predicate notice to the tenant, either a rent demand or lease termination, followed by filing with the court. It's called a notice of petition, and a petition is the underlying complaint that has to be served in certain ways on the tenant. There's a hearing, and if the tenant doesn't raise enough eviction defenses, isn't successful, the court will issue a warrant of eviction, and that is an order to, for example, in Utica. So it's either the Oneida County Sheriff's Office that will do evictions, or the Utica City Marshal. And who has jurisdiction to do evictions is a local question, municipal question. But and in practice, and then the sheriff or marshal or constable will serve notice on the tenant. It means giving them a copy of the warrant, and then there's a built-in 2-week period delay before the actual eviction can happen. And what eviction looks like in practice is, So for example, in Utica, the Utica City Marshal, I know, will generally, what evicting means is changing the locks on the apartment and giving the keys to the landlord. If you are if you are served with a warrant of eviction, you do want to make every possible arrangement to have your take care of your personal belongings, move them to somewhere safe, find alternative shelter, etc. But we have some success working with the marshal and a landlord, even after the locks have been changed, to give our clients a few days to collect their things. That's something to ask for if you really need to.
Before we get to the warrant of eviction, I mean, there might, you kind of have situations where there is, okay, we haven't been paying rent. We have not had the capacity to pay rent. We're behind.
Mm-hmm.
And now you feel like you're starting to get the process is moving forward and they don't know what to do, but there's options available. As we said, there's things that renters can do to stay in their home. So if you've received a court summons, if it's gotten to like kind of the initial stages, maybe, what options do you have? What would you advise somebody in that position to do?
The minute, being served court papers can happen in a number of ways. They're legally prescribed, but your landlord or his process server is supposed to make a good effort to serve it to you personally, which means handing it to you, the papers to you. But if they make a few attempts to do that and they can't, they can then do something used to call nail and mail, but no one nails process on doors anymore. You affix it with tape, or you can shove it in some secure way. But if you do that, you also have to mail copies of the notice of petition and petition to the tenant, one by certified mail, which means you can track and see if it's delivered. One thing we always, urge people is don't ignore those papers. I'm guilty of avoidance. I think everyone is very tempting to, put your head in the sand when something terrifying like that comes across your desk. But it's better to face it and call, your local legal aid. So LASMNY and our sister firm, Legal Services Corporation in New York, they have a pooled legal helpline. And so anyone can call and say, I've been served these papers, what should I do? And get at least advice, if not representation. And of course, we will, evaluate your case for representation and provide it if you're eligible and if we can. But that's the first thing I would do is, if nothing else, call a legal services hotline and get some advice. The other thing is it's never a good idea just to not show up to court. If you do that, the court will issue something called a default judgment, which essentially means, the judge looking at the papers will say, okay, there's a notice, there's a petition that was filed, here's a notice, there's an affidavit of service. Maybe you didn't in fact get it, but there's an affidavit of process server saying they did what they're supposed to do. So the court looks at that and says, okay, you had your day in court scheduled, you didn't show up. So they're really bound to, at that point, issue a judgment in favor of the landlord. And a judgment, it means two things. One, a judgment of possession and a warrant of eviction will be issued that day against you. But two, if there is past due rent, a monetary judgment will be issued against you. And that can be very problematic. Monetary judgment hurts your credit. A landlord, if they chose to sort of execute it, to collect that, they can garnish your wages. It's not pretty. So a default judgment is something I think you really want to avoid. Better to show up and make your best defenses and just explain to the judge why you fell behind in rent. If there are serious conditions, things that are wrong with the apartment that landlords refused to fix, and you felt like, I didn't have heat for 4 months this winter. It didn't seem right that I should be paying for, paying for rent or paying full rent. And that's, you just to go out and make even if you don't have an attorney, go make your best arguments. You can also ask for a 2-week adjournment. and use that 2 weeks to contact legal aid and try and get counsel.
Okay. Next question, Emily.
Yeah. So if there were a situation where a landlord wanted the tenant out and they've cut off utilities, changed locks, thrown away belongings, what is it that a tenant can do in that situation?
So
contextually, I just wanted to say, so like if they weren't following the process through the courts and they were just changing the locks, cutting off utilities and trying to get the tenant out, what should a renter do?
So that's changing the locks, going in and moving a tenant's possessions for them, cutting off basic utilities like heat and water. Those are all what's called unlawful eviction. And there's now a statute on the books that makes it a Class A misdemeanor. So if you are locked out, if your landlord shows up with a locksmith, to change the lock, the first thing you should do is call the police. Now, it's a new law. It's newly a misdemeanor crime. And so not all police departments in the state are, really familiar with it or perhaps comfortable, arresting a landlord. There's a lot of sort of prejudice or common sense, but just a feeling of this is this person's property. They're not getting paid. Why shouldn't they be entitled to possession? So the New York State Attorney General, Letitia James, has put out an incredibly helpful document called Guidance for Local Law Enforcement on unlawful eviction. And with questions the police that arrive should ask, explaining the law. Anyway, I will sometimes give that guidance document to clients where it's a really heated situation and I'm worried that something like this may happen. I say, you can hand this to the police when they arrive. But yeah, that's the first thing, is just to stay calm, call the police, explain that, if your landlord is doing any of these things without a warrant or, certainly without a sheriff or constable there, it's an unlawful eviction. And, you'd like them to arrest the landlord or stop him from doing it, The other thing is, and you can also bring, an affirmative claim in small claims court. We don't do a lot of affirmative litigation. Most of our caseload are trying to keep people housed, where they have meritorious defenses to eviction. But there is a sort of societal benefit in us enforcing this law. Why? Because it's new. As I said, a lot of landlords have for a long time operated their properties on the basis that this is mine. I can do with it what I want. And so part of really instructing the community on how to follow this new law will be enforcing it with a claim for something called treble damages. So we were working with a family whose landlord hired movers. It was silly because it was like a few days before the warrant was effective or would have been executed. Anyway, hired movers to go into the house and move these, people's belongings. And so in that case, we sort of added up the value of the property they lost, what their damages were, and make a claim for 3 times that amount. So there are also there's a fine enforcement mechanism, but that's not something that you, the tenant, will bring.
Awesome. We're gonna, okay. Want to make sure.
Oh, sorry, Alex. I should also add the New York Attorney General's office does have an online form for reporting unlawful eviction. Again, I think like legal service providers, everyone wants to sort of educate, the landlord community as well as tenants about this new law. So they're focused on that too.
Awesome. We'll link the guidance from the Attorney General's office, Letitia James, on local law enforcement evictions guidance. I believe you said we'll link that below. And as well as we'll put out the link to report unlawful eviction. That's great. Thank you for that information. That's stuff I didn't know. We were talking a little bit before the town hall about withholding rent, or the possibility of, there's things within the apartment or the building or the the house that is not that needs to be fixed, and thus the tenant takes on kind of the project.
Right.
So how is that possible? How does that work? Is it possible to withhold rent for small things or big things, and how are you seeing that play out in court?
So I would say, and I don't know if this is sort of a reflection of the city that I practice in right now, but I would say I did take a look at the numbers in my cases so far, and I think 65% of the tenants that I've worked with in eviction cases have reported, conditions to me that are serious enough to be what are called breaches of the warranty of habitability.
Wow.
And I think things like roach and rodent infestations. I've had a few cases with where there are real bed bug infestations, and a family showing me pictures of their children's arms covered in bites, and they're low income to begin with, and then you have to buy replacement mattresses and upholstery. It's a lot
Sure.
for a family to go through. Untreated, like plumbing leaks that are untreated and then cause black mold, or create dangerous situations where you have leaks right next to, electrical wiring in the ceiling, windows that are so rotten, the frames are so rotten that a pane of glass falls out in the kid's bedroom, in the middle of winter, that kind of thing. And, the standard for what kind of condition is so serious that there's sort of legal redress for a tenant is that the landlord guarantees that what they're renting you is fit for human habitation or for use reasonably intended by the parties, and that the premises won't have any conditions which are dangerous, hazardous, or detrimental to life, health, or safety. So not everything that goes wrong in your apartment is going to rise to this level, but many of our clients do live with, serious conditions like this that are unaddressed. So I think the big takeaway for any tenant is that withholding rent is never your first go-to. It's really important, even if frankly, you think, my landlord's been rude to me, I can never get a hold of it or them. What's the point in telling them about this when I know they won't do anything? You always start with a written notice to your landlord of the condition and a request that they repair. Why? Because if you don't sort of start with that, you're going to have a very hard time in court justifying withholding rent or deducting expenses of a repair. So you want to start by, a text, an email, a written note with a date on it, anything you can to sort of create a record that you're asking them. Then you give your landlord a reasonable period of time to fix it. And that depends, right? If there's water gushing through your ceiling, a reasonable period of time is like today. But, something like, an oven is not working. It might be more reasonable to give them a week. So it depends on the situation, but you give them a reasonable time to address it. And if they don't, your next step should be to call the codes enforcement officer, and you can do a Google search, so the name of your city or town, codes enforcement officer, and I can usually get an email and or a phone number that way for codes enforcement. And so you want to report the condition to them. Some clients have reported upsetting things, like saying they've called multiple times and they're told by codes, well, why don't you try paying rent? Maybe then your landlord will fix it. Regardless, it's a step you want to take. And again, you want to get some kind of record that you made a report with codes. Finally, if that still doesn't work, at that point, then you can think about financing the repair yourself. And so before you do that, you want to, give the landlord written notice again saying, look, I've reached out to you before, you still haven't fixed it. If it's not fixed by X date, like end of the week, end of the month, whatever, I am going to withhold X% of the rent or X $100 of the rent. And I'm going to save that money so that I can use it to make the repair myself.
Right.
And, if it's something like, for example, I was talking to a young couple today who have had, for months, a horrible rodent and roach infestation in their apartment. And, you know, I said, okay, so get an estimate for an exterminator. And, you know, we'll send a letter to your landlord today. We'll say, this is the estimate you got. You know, you can't afford to both pay for the extermination and pay your rent. So you're going to deduct the cost, you know, from your next rent payment. So that process is important. And again, you know, if nothing else, if you're thinking about doing something like that, again, try and call a local legal services organization and just say, this is what I'm doing. What do you advise? And maybe they'll write the letter for you, for example.
Awesome. I think it's interesting too, because you don't necessarily realize how many ways there are to document something. You know, some people say like keep a record. What was that like? You know, opening up like a paper and say I did it. But nowadays, like you said, like text messaging, writing an email, there's like ways that you can document things that need to be repaired and communications with your landlord if they're failing to meet their end of the lease. So
I know someone who isn't a big fan of writing in general, and so they do voice notes, you know, on their phone to document things. And sort of a contemporaneous record, meaning like a record you make at the time you reach out to the landlord, you know, something that's time and date stamped, like a voice recording, a photograph, etc., an email, text. Those have more credibility. You can't create them after the fact.
Right. All right. Next question, Emily.
Yeah. So if during this housing crisis, a landlord is trying to increase the price of rent for a tenant, what can be done to help with that?
So it depends. So if you have a lease, you have a written lease, let's say for a year, like I do with my landlord, for example, that lease is a contractual agreement. And the agreement is that I will pay her a certain amount every month. And in return, I will have use of the property, right? If she, you know, unilaterally raised the rent and said, okay, this month, Clara, you know, I want $1,000 more a month, that would be a breach of contract, and I wouldn't be required to pay it. A lot of tenants don't have a written lease, and they're renting month to month. And so if you're in the property for a long time, maybe you signed a lease initially, that was good for a year, you continued to live there after it expired, you're at that point deemed to be renting on a month-to-month basis on the terms of the written lease. So when you have a month-to-month lease, a landlord can terminate your lease for any non-discriminatory, non-retaliatory reason. So for example, let's say like in our area, rents are shooting up and the landlord says, okay, I've got an opportunity to make, you know, more money off this property if I can rent it to someone who can pay a higher rent. That is a legitimate reason to terminate a lease. So the landlord does have to follow though, like certain procedures. And so written notice of termination is required. It's either 30, 60, or 90 days advance notice to the tenant. And it depends on how long you've stayed in the property or whether or not you have a lease for a year or more. So they do have to follow the process. And the point, I think, of that notice period, I worked in front of a judge recently, you know, who's like 3 months, like 90 days. Wow, that is so much time, you know, but people need it, particularly those of us who live sort of paycheck to paycheck, right? You need time to save up money for the security deposit, to save up money for first month's rent on a new place. Right now, one of the sort of unfortunate effects of the eviction moratorium was that it kept everyone housed during this incredible crisis. But because people weren't, you know, being evicted or moving on their own, the market is incredibly tight. Like there are just, we just hear over and over from clients that, you know, there was a family I overheard, like in court when I was waiting for my case to be called this morning, who said that they had spent $200 on application fees and had submitted 100 applications already. You know, they were dying to leave, but they just couldn't find anything. So that notice period is really important to respect because tenants need it, you know, to find new housing and pay for it. So that's, you know, sort of tough luck, right? It's a market. If you're in that situation. So if you have a written lease, you know, the rent is agreed, you're protected. The other thing is that I think it's over 5%. A rent increase of a certain amount also requires advance notice, just like termination would.
So the takeaways I'm getting is that there are options available for folks if they need them who are in the tenant situation. A lot of times in that situation, as a renter myself, you feel like all the power is with the landlord. However, there are things that you can do as a tenant, and I think just being aware of those are huge. And I think the other big takeaway was definitely show up to court. I think the thing that you said, when you don't show up to court, you just kind of ignore it, as people do sometimes. They kind of hear no evil, see no evil.
Right.
And that's where you've kind of you've given up some power that you possibly could have in an eviction case.
Right. And we can, sorry to interrupt.
Go ahead.
If that does happen to you, if you call legal aid for advice, and if you qualify for representation, you'll have an attorney helping you. But if you miss, for a good reason, like I have definitely had several clients who the first time they hear anything about the eviction case is when they're served with the warrant, and then we go back and we actually look, and yes, there's an affidavit of service, but we look, we track the certified mail receipt on the postal, website on the track, and it turns out it was returned to sender, so people sometimes really just don't get notice of the proceeding so by the time you get a warrant, that means, you missed your day in court and there was a judgment. So if that happens, and that's a good reason, right, for not showing up. If you don't know about the case, you don't get notice of the court date, you can't be there. And you can't, you don't have the papers, you can't make your defense. Anyway, if that happens, you can contact local legal aid and ask them to do what's called an order to show cause, which is to reopen the case. And in general, most judges understand very clearly that there is a strong public policy, preference for resolving disputes on the merits. So if you have a good reason for missing court, most judges are willing to reopen the case. You just have to do it. It's a good idea to have a lawyer help you with the process.
With that, I'll give the final question to Emily.
Yeah. So how would someone qualify for a legal aid attorney?
So again, we're federally funded, and the idea is that our services are available to low-income people who can't afford a private attorney. And so when you call, for example, our helpline, and Alex, I don't know if the helpline number is
I'll give it out. I just want to make sure. I think I know it, but I don't want to get a digit wrong. Sometimes I get digits wrong, but go ahead.
Yeah, me too. So they will ask you the helpline intake staff will ask you a series of questions about, how much you make per month. Sometimes that can be offset with certain kinds of expenses, but, it's a very specific calculation they will have to do. But if you qualify for our services, your case is then referred to a staff attorney, and, we bend over backwards to take every single case that we can. There aren't enough legal aid attorneys just to serve the population, but we do work really hard to represent people when we can.
Yeah, I would advise everybody to, if you are facing an eviction and you've had hardship via COVID-19 or, just anything, call our 1-877 number, and that's 877-777-6152. And that's how our paralegals triage cases. Sometimes things fall under, you can qualify for cases depending on, it's very unique. Everybody has a very unique situation. So they go through kind of an in-depth process of your background, and obviously your income's part of that as well. I also recommend applying for services online, in which you can kind of get some of that documentation that you need online, and you just go to LASMNY.org. There's several links to our application portal, and just apply for services there. And again, I also caveat with there has been an influx of cases since the moratorium's lifted, and obviously the other kind of effects that have happened since COVID-19. We also do legal aid does domestic violence and sexual assault work, disability advocacy, foreclosure help, which is also continuing, divorce and bankruptcy clinics, and as well as we have a farm worker law project based in Falls, New York. So just bear with us as we do try to get those calls returned and have, like I said, pretty in-depth discussions with clients and potential clients. So anything else that I missed, Clara? Anything in closing?
Sometimes tenants will ask, can my landlord evict me because I complain about a condition to codes? And you see that all the time, that people will put up with an enormous thing, things that I would, people will put up with a lot to keep a roof over their head.
Yeah.
Your kids in the local school to finish out the year anyway. So they're anxious about contacting codes. And so there is a statute in New York that against what's called retaliatory eviction. So I would not, sort of let something that's a safety hazard in your home go unaddressed because of that fear. If your landlord brings an eviction proceeding within 12 months after, for example, you contact codes or you contact a legal aid attorney to help you, get something fixed, within the 12 months after that eviction, there's a presumption that the eviction is retaliatory. And so that means that the landlord has to sort of prove to the judge that they have a non-retaliatory reason. Of course, in non-payment, that's a little easier to meet, but you will have, landlords who decide, cheaper to have the building condemned than to fix it. So you have some protection from that.
All right, Clara, thank you so much.
Thanks,
Emily,
Alex.
thank you so much. And thanks everybody for watching the town hall today. We hope to continue to have them. And like I said, if you do need help with evictions, please do call our 1-877 number, and that's 877-777-6152. That's 777-6152, as well as our online application process, which is simply at lasmny.org, LASMNY.org. We serve 13 counties in central New York, from Watertown down to Binghamton, Syracuse, and of course our headquarters is in Utica, New York. Thank you so much. I appreciate it.
Thank you both.